She called my custody petition adorable. She said it with a smile, in front of attorneys and a mediator, while looking at the scar on my neck. What she didn't know, what no one in that room knew, was that I had been building something she couldn't see, and I had been building it for a very long time. Would you bet against a father who never once raised his voice? My phone rang at 7:53 on a Tuesday morning. I was pouring orange juice. My lawyer said the case had been reopened. He said a custody modification had been filed overnight. He said my visitation was suspended, effective immediately. I set the juice down. I knew exactly what this was about. 7 years earlier, I was sitting in a gray plastic chair on the 4th floor of the Cook County Family Court building. The chair was cold. The fluorescent lights buzzed above me. The room smelled like old paper and someone's burned coffee from a machine in the corner that nobody trusted. I had been waiting 2 hours. My name is Daniel Reyes. I am a patient man. I have always been a patient man. That is not a small thing. That is the most important thing about me. My daughter, Camille, was 6 years old that morning. She was at home with my wife, Helen. Helen had packed me a lunch I hadn't eaten. She had said, "Call me when it's over." I had said, "I will." The woman across the table from me was named Sylvia Hargrove. She was the chief executive officer of Hargrove Capital Partners. She was also Camille's mother, though she had not been present for most of Camille's life. Sylvia's lead attorney was a man named Garrett Fisk. He billed $875 an hour. He was very confident. He had a way of speaking that made everything sound already decided. Sylvia sat beside him with the posture of someone who had never lost anything important. She had 3 attorneys at that table. I had one. Her name was Constance Park, and she was trying her best with what we had. Garrett Fisk presented his documents first. He said I was financially unstable. He said I was professionally disgraced. He cited an incident report from my former employer, Hargrove Capital Partners, Sylvia's own firm, where I had raised my voice in a meeting after they asked me to sign a non-disclosure agreement. I had raised my voice once in that meeting and then I had never gone back. Garrett Fisk called this a pattern. Sylvia looked at me across the table. Her eyes moved to the scar on my neck. It runs from below my left ear to my collarbone. I got it when I was 19 years old, pulling my brother out of a car fire on Interstate 55. My brother survived. I healed. The scar stayed. Sylvia looked at it the way people sometimes do, quick, then away, and then she looked at my face and smiled. "You're fighting for primary custody of a child you won't be able to provide for," she said. She paused. "I find that adorable." Garrett Fisk did not react. He had heard his client say harder things. He was already moving papers, already preparing for a proceeding he believed was over. He signed something on his legal pad with a quick, confident stroke. Constance Park put a hand on my arm under the table. I did not move. I did not raise my voice. I looked at Sylvia Hargrove and felt nothing she expected me to feel. At the end of the session, I was handed a document. It was a preliminary custody determination, case number 2019 FC 4471, signed that morning by Judge Marilyn Halvorson. It recommended temporary primary custody to Sylvia Hargrove pending full evaluation. It listed my visitation as every other weekend, supervised. I read it carefully. I read it a second time. I folded it once, lengthwise. I put it in my coat pocket. Garrett Fisk was watching me from across the room. He had seen men get angry at documents like this. He had seen men crumple papers, or throw them, or stand too fast. He was ready for that. He was not ready for what I did. I said, "Thank you." I picked up my folder. I left. In the parking garage, Constance Park walked beside me. She said, "Daniel, we have a difficult road." I said, "I know." She said, "Their financial argument is strong." I said, "I know." She said, "I want to be honest with you about our chances." I said, "Please." She said 40-60 in Sylvia's favor. She said it with the quiet voice of someone who wanted to be wrong. I nodded. I thanked her. I walked to my car. Inside the car I sat for 4 minutes without starting the engine. I took the custody document out of my coat pocket. I unfolded it. I read it a third time. There was something in section 4, paragraph 2, line 8, a date reference, a case number, a single statute citation that pointed somewhere no one in that room had followed. I did not say this out loud. I did not call Constance Park. I folded the document back into my pocket. I started the engine. When I got home, Helen was waiting at the kitchen table. Camille was in the next room, 6 years old, building something with blocks. Helen looked at my face. She said, "What did the judge say?" I sat down. I took the document out of my pocket and set it on the table between us. I looked at it. I said, "We'll see." Helen looked at me the way she always looked at me when I said things she didn't fully understand but trusted completely. She put her hand on mine. I was already 3 moves ahead. This case is about to take a turn nobody in that courtroom expected. And it's all because of something buried in a document they never thought anyone would actually read. Before it gets there, hit subscribe and turn on notifications. Because the moment I found what I found, even my own lawyer said, "Where did you unearth this?" And that's when everything shifted. Don't go anywhere. Life continued. That is the part people do not expect. I still drove Camille to school at 7:45 every morning. I still made dinner. I still picked her up at 3:15 every afternoon. Every other weekend I dropped her at Sylvia's building downtown and sat in the car for a few minutes before driving away. I kept moving. But every evening, after Camille went to sleep, I sat at the kitchen table with a yellow notepad and read documents. Helen noticed within the first 2 weeks. She didn't ask right away. She made coffee and sat nearby, reading her own things, giving me space. On a Friday night in November 2019, she set a cup next to my elbow and said, "What are you looking for?" I said, "Something." She said, "Will you tell me?" I said, "When I know, you'll know." She sat down across from me and did not push. That is the kind of woman Helen is. I started at the Cook County Courthouse Records room the following Tuesday. It was in the basement. The hallway smelled like old carpet and dust and the particular staleness of rooms where important things go unread. A woman named Doris ran the room. She had worked there 22 years. She showed me the filing system without asking why I needed it. The boxes were heavy. Some of them had not been opened in years. I wore the same jacket every time I went. I brought my own pens. I brought my folder, tan manila, soft at the corners from carrying it everywhere. I took notes on yellow paper, in my own block handwriting, and kept every page. The fluorescent lights in that basement buzzed the same way the lights had buzzed upstairs in the courtroom. I found that comforting. It meant I was in the same building as the truth. I was looking for something specific. I did not yet know its exact shape. I knew it had to do with Illinois custody law, with the 24-month caretaking window, with how courts measured a parent's involvement when one parent had been traveling. I had read the statute, Illinois Marriage and Dissolution of Marriage Act, Section 602.7. It said the court must consider time spent performing caretaking functions in the 24 months before filing. Not earning power. Not job title. Time. The question was how the appellate courts had interpreted that word. I went Tuesdays, Thursdays, and Saturday mornings. Camille was 6, then 7. She knew I read at night. One evening she came downstairs for water and found me at the kitchen table with 3 binders open. She said, "Dad, why do you always read?" I said, "To help us. To help you." She nodded and went back upstairs. She was 7 years old. She accepted that because she trusted me. That trust was the weight I carried into every courthouse basement. I searched records from 1995 through 2012. I worked through 43 binders. I made 211 photocopies on a machine in the basement that hummed and occasionally jammed on thick paper. The smell of old documents is specific. It is dry and faintly sweet, like something that used to matter and still does. I learned to love that smell. I found it on a Tuesday afternoon in November 2020, 14 months after the preliminary custody hearing. Box 7, Binder 3, Tab 11. In Re-Marriage of Alderton v. Caldwell, Cook County Family Court, 2011. Affirmed Illinois Appellate Court, 3rd Division. I read the summary. I read the ruling. I read it again. The lower court in that 1998 case had ruled that a parent's financial contributions offset reduced caretaking time. The appellate court had reversed. The ruling was 12 pages. Page 9, paragraph 3 was the one that mattered. It said, "Caretaking functions are measured by documented physical presence and direct involvement, not by financial contribution or professional status. A parent absent for extended periods, even for professional reasons, cannot claim shared caretaking credit for those periods." Sylvia Hargrove had been traveling for business by her firm's own published calendars. I had printed every quarterly newsletter, every investor update, every conference announcement, for a combined 247 days during the 24 months before she filed her petition. The Alderton ruling said those 247 days were not caretaking days. The preliminary custody determination had never cited Alderton. Not once. I sat in the basement with the binder in my hands. The copy machine hummed. The lights buzzed. I read the ruling a fourth time. Then I stood up, walked to the copier and made 2 copies. One for the folder. One for somewhere safe. That evening I called a man named Gerald Osei. He had passed the bar in 1994 and knew Illinois family law the way some people know scripture. I read him paragraph 3 of the Alderton ruling over the phone. There was a long pause. He said, "Where did you find this?" I said, "Basement. Courthouse. Box 7. He said, "The judge never cited this case." I said, "No." He said, "Daniel, this changes everything." I said, "Yes." I told Helen that night. She was sitting at the kitchen table when I came in. She looked at my face. She said, "You found it." It was not a question. I sat down. I put the copy of the Alderton ruling on the table between us. I said, "The precedent is real. The appellate ruling is binding. Their argument collapses under it." She put both hands around her coffee cup. She was quiet for a moment. Then she said, "What do we do now?" I folded the document carefully and placed it inside the front cover of my folder. I said, "Now comes the long part." I said, "But I have time." I closed the folder. Outside it was raining. I did not feel the rain. I had what I needed. Year 1 passed. Then year 2. Camille turned 8. She lost her 2 front teeth and grew them back. She joined a robotics club on Thursdays. I drove her every Thursday. I picked her up every Thursday. I made dinner. I read documents at night. Life continued in both directions at once. Forward as a father, patient as a man who knew something nobody else in this case had found yet. In the spring of year 2, Garrett Fisk called Priya Suresh. Priya was my new attorney, assigned through the Chicago Bar Association's legal aid clinic. She was 28 years old and sharpened by the knowledge that she had to be twice as good to earn the same result. Garrett Fisk did not know this about her. He would learn. Fisk told Priya my client should take the offer. The offer was 35% physical custody, every other weekend, with Sylvia holding primary residence and all decision-making authority, plus a $400 monthly child support payment from me, plus a non-disclosure agreement. Priya called me that afternoon. I said, "No." She said, "He may increase the offer." I said, "He will increase the offer." She said, "Are you sure about this?" I said, "I'm sure." He increased the offer. 45% custody. Alternating weeks. Joint decision-making on education and healthcare. No support payment. I read the offer at my kitchen table on a Thursday night. Camille was in the next room. Gerald the robot was veering left again. I could hear her troubleshooting under her breath. I wrote one word on the offer document. No. Year 3. Camille was 9. Sylvia's attorneys had been denied on 4 separate motions. Garrett Fisk's face, in the photographs Priya showed me from courthouse filings, had changed. There is a look people get when they realize the thing they dismissed is not going away. He had that look. In January of year 3, Sylvia contacted me directly. She suggested coffee. I agreed. We sat at a table near the window of a place on Michigan Avenue, and she looked older than I remembered, or maybe I was just looking more carefully. She ordered something complicated. I ordered black coffee. She said, What will it take, Daniel? I looked at her. I said, what I've always wanted. She said, tell me the number. I said, it's not a number. She said, everything is a number. I said, not this. She pushed the cup. She said Camille was happy. She said Camille was thriving. She said I was putting my daughter through unnecessary stress. I looked at her. I said, no. She said, Daniel. I said, no. I picked up my coffee. She looked at me the way she had looked at me 7 years ago in the mediation room, like I was someone who did not understand what was happening. She was wrong then. She was wrong now. Year 4. Camille turned 10. Helen's hair was going gray at the temples in a way I found beautiful. I kept the Alderton ruling in the front of my folder. I read it sometimes in courthouse waiting rooms, not because I had forgotten it, but because reading it reminded me of the shape of what I was carrying. A man who knows what he knows does not get anxious. He gets patient. At a coffee meeting between Priya and Garrett Fisk, Fisk said something he had never said before. He said, what does he want? Tell me what he wants and I'll give it to him. Priya told me that evening. She said his voice had been different. I said, what do you mean different? She said, like someone who just realized they're not winning. I said, how long have they known? She said, I think longer than they admitted. Year 5. Camille was 11. She had started asking quiet questions. One evening she said, Dad, why don't you ever get mad at her? I said, because I know what I know. She said, what do you know? I thought about the Alderton ruling. I thought about 247 days. I thought about 2,914 calendar entries, one for every morning and evening I had been present. I said, that the truth is patient, and so am I. She looked at me the way she had looked at me when she was 7 and I said I was reading to help her. She accepted it. She went back to her homework. Year 6. The third offer was not a number. It was a list, a house, a car, 60% custody with me as primary, a monthly payment from Sylvia of $1,200, full medical and educational decision-making shared equally. Everything I had been asking for, plus money I had never asked for. Garrett Fisk sent it through Priya on a Wednesday afternoon. I sat with it for 11 minutes. Then I called Priya. I said, no. She said, Daniel. I said, no settlement. Nonda. No quiet arrangement. I want a ruling. Priya was quiet. Then she said, you have something, don't you? I said, I've always had it. 2 weeks later, Garrett Fisk sent a message through legal channels. It was 3 sentences. It said his client wished to negotiate directly. It said his client acknowledged the current arrangement was not serving the child. It said his client was prepared to discuss terms. I read it at my kitchen table. I did not smile. I did not call anyone. I pulled out the folder. I looked at the Alderton ruling in the front pocket. I put the folder down. I picked up the phone and called Priya. I said, tell them yes. I said, now we can talk. The long part was over. The mediation room was on the 3rd floor. It had the same cold chairs, the same long table, the same fluorescent light hum as the room 7 years before. I sat down and put my folder on the table in front of me. I did not open it yet. Garrett Fisk looked older. Sylvia sat 2 chairs away from her own attorney. That told me everything I needed to know about where they were. The mediator was a retired judge named Harlan Bates. He folded his hands. He said, let's discuss custody arrangements. Priya Suresh stood. She spoke for 9 minutes without notes. She cited the Illinois Marriage and Dissolution of Marriage Act, Section 602.7. She cited case number 2019, FC 4471. She cited in Re-Marriage of Alderton v. Caldwell, 2011, affirmed Illinois Appellate Court, 3rd Division. She said, Your Honor, the Alderton ruling is binding precedent in Cook County. It establishes that caretaking functions are measured by documented physical presence, not financial contribution. The preliminary 2019 custody determination never cited this case. Not once. She paused. She said, Sylvia Hargrove was absent from her daughter's life for a documented 247 days during the 24 months before petition filing. This is verified by Hargrove Capital Partners' own investor newsletters, quarterly reports, and the deposition of her former assistant, Ramona Castillo. She set the documents on the table. Garrett Fisk leaned toward Sylvia and said something quietly. His voice was low. His posture was not what it had been in that room 7 years ago. Sylvia looked at the documents. She looked at my folder. She looked at me. I looked back at her. I did not say anything. Priya set one more document on the table. She said, This is a 2,914 entry parenting calendar, timestamped, beginning the day Camille Reyes was born. It documents every school pickup, every pediatric appointment, every permission slip, every sick day, every school event. It is corroborated by independent records, Camille's pediatric file, the school's attendance records, and an email produced in Discovery in which Ms. Hargrove's assistant asked whether she intended to attend her daughter's kindergarten graduation, and Ms. Hargrove declined due to a scheduling conflict and asked the assistant to send a gift card. The room was quiet. Judge Bates looked at the email. He looked at the Alderton ruling. He looked at the calendar. He said, Counsel for the petitioner. Is this ruling cited anywhere in the original determination? Garrett Fisk said, No, Your Honor. Judge Bates said, And the caretaking time documentation? Is this contested? Garrett Fisk said, The methodology. Judge Bates said, Is the documentation contested? A long pause. Fisk said, No. Judge Bates looked at the table. He said, The Alderton precedent applies and was not cited in the original determination. The caretaking record is extensive and independently corroborated. The court finds the original custody arrangement must be reconsidered. He looked at both attorneys. He said, I recommend primary physical custody be designated to Daniel Reyes, with Sylvia Hargrove receiving parenting time on a graduated schedule beginning at 30%, with provisions to increase to 40% after 12 months of consistent engagement. He said, Joint legal decision-making on education and healthcare, effective immediately. He said, Sylvia Hargrove will pay $800 per month in child support. He said, A parenting agreement will be filed within 30 days and will constitute a permanent order, challengeable only upon substantial new evidence of changed circumstances. Sylvia did not speak. Garrett Fisk gathered his papers. He did it slowly. He did not look at me. Priya shook my hand. She said, You were right. The whole time you were right. I said, Yes. We walked out. The sun was out. It was an ordinary day. The world looked the same. I picked up Camille from school at 3:15. She was 12 now. She got in the car and looked at me. I was smiling in a way she said later she had never seen before. She said, What happened? I said, We won. She said, What does that mean? I said, It means you're staying with me. It means I'm your dad, and nobody can take that away. She put her arms around me in the front seat. We sat there for a moment. Then I started the car. We drove home in silence. That evening I sat at the kitchen table. The custody order was in front of me. I read it carefully, word by word. My name, Camille's name, the terms that would govern the rest of her childhood. Helen sat down beside me. She put her hand on my shoulder. She said, You did it. I said, We did. I folded the custody order once, carefully, and walked to my home office. I placed it on the shelf. Not in my coat pocket. Not in the folder. On the shelf where it would stay. I looked at the shelf for a moment. The folder was beside it. Soft at the corners from 6 years of carrying. I left them both there. I went back to the kitchen. I made dinner. Some men fight with their fists. I fought with patience. A father who knows the truth does not need to raise his voice. He only needs to wait until the room is quiet enough to hear it. The order sits on a shelf in my home office. Camille is 12, and she is safe, and that is everything. I never had to explain myself to anyone. I only had to wait.